Good afternoon, everyone, and a very warm welcome to the Irish Human Rights and Equality Commission's public space to discuss citizens' free movement in the EU's neighbourhood. In particular today, I'd like to welcome Professor Dagmar Sheik from the Jean Monnet Centre of Excellence in UCC, who has organised this event and was with us also actually here last November for a really excellent conference, and who is co-chairing today's event with Dr. Mary C. Murphy, also from UCC. So we're really very pleased to host you for this important discussion today. And we're delighted to welcome also the guest contributors, Dr. Anthony Soares, who I believe is online today, Director of the Centre for Cross-Border Studies, whom we know very well here in IREC, Dr. Oksana Holovka-Havrvsheva, Associate Professor, Ivan Franco, National University of Lviv, Ukraine, and Tatsiana Shaban, who is from the University of Victoria. So, unfortunately, the Chief Commissioner couldn't be here today, but as the new Director of IREC, she's asked me to make a few short welcoming remarks about the Irish Human Rights and Equality Commission and the issues that we are working on here that relate to the theme of today's event. So, founded as part of the Belfast Good Friday Agreement, along with the Northern Ireland Human Rights Commission, the Irish Human Rights and Equality Commission is, as you know, Ireland's independent national human rights institution and also the national equality body. So following Brexit, along with the Northern Ireland Human Rights Commission and the Equality Commission of Northern Ireland, we now have been mandated to oversee and to report on its implications for human rights and equality on the island of Ireland. This we do specifically in relation to Article 2 of what's now the Windsor Framework, previously known as the Protocol in Ireland and Northern Ireland. In Article 2, the UK government commits explicitly to ensuring that no diminution of certain rights, safeguards, or equality of opportunity, as set out in the relevant chapter of the Good Friday Agreement, arises from its withdrawal from the EU. And in recognition of the key that EU anti-discrimination law has played in underpinning the provisions on equal treatment in the agreement, Article 2 also includes a commitment to Northern Ireland law, keeping pace with the core protections against discrimination enshrined in EU law. Article 2 specifies that this commitment be implemented through some dedicated mechanisms, namely the two Northern Ireland Commissions, who work together with ourselves here in IREC, specifically in relation to rights and equalities issues that have an island of Ireland dimension. The Article 2 commitment and our joint work to ensure it's upheld is so important because it aims ultimately to protect the centrality of equality and human rights in the agreement, including its requirement that there be an equivalent level of protection of human rights in Ireland as in Northern Ireland. To support this work, here in IREC, we've developed research and joint policy recommendations on the impact or potential impact of Brexit in relation to the divergence of equality and human rights protections on the island of Ireland. And in light of the findings, it's timely to note that the three commissions have made two specific recommendations on which the three leaders of those commissions engaged with the Oireachtas Joint Committee on the implementation of the Good Friday Agreement just this last Thursday. So the Commission's recommended that the North-South equivalence of rights and protections be ensured by Northern Ireland law, keeping pace with changes to equality and human rights law arising as a result of EU laws introduced on or after the 1st of January 2021 that enhance protections. This should include rights introduced as a result of EU laws that do not amend or replace the Protocol Annex 1 directives. They also recommended that the Irish Government, Northern Ireland Executive and UK Government work to enhance and harmonise equality and human rights protections on the island of Ireland, aligned to their respective remits, and make a clear commitment to working towards ensuring North-South equivalence of rights on the island of Ireland so as to strengthen those protections. And if implemented, these recommendations would help to avoid a divergence of rights that would not only see rights protections diminished in Northern Ireland, but would also run contrary to the vital commitment on equivalence that's set out in the agreement. On the Common Travel Area, an earlier research commissioned by IREC and the Northern Ireland Human Rights Commission in 2018, it was recommended that both the Irish and UK governments should look to secure a gold standard approach through a new intergovernmental Common Travel Area Treaty. Such a treaty would formalise common immigration rules, travel rights, residency rights and related rights to education, social security, work, health, security and justice. As we are all aware, we're living through a humanitarian crisis in Europe at the moment, sparked by the devastating invasion of Ukraine by Russia. So it's more important than ever that European countries have a humanitarian response that reflects both the needs and realities of a world where crisis and flux is the norm and unfortunately not the exception. So we hope that the discussions here today will help broaden our understanding of the challenges as well as the opportunities that may arise at this time in relation to citizens' free movement in the EU's neighbourhood. On that note, we're delighted to host you in our public space. We welcome you again, and we wish you a very successful event today, both online and in person. And with that, I will hand over to your chair, Dagmar Sheik. Thank you, Professor.
Thank you very much, Deidre, and also thank you very much for hosting this event. My name is Dagmar Sheik, and I've been introduced already. And our center is really working about the idea EU integration and citizens' rights. So what are we doing overall? Yeah? So our research question is, can the EU regain its legitimacy by ensuring that citizens can actually engage with the other through using rights? And when we talk about rights, we often think of barristers and legalese and stuff, and I'm a lawyer as well, but rights also have a political dimension, and they have a dimension where people can engage with each other, where people can build their hopes on rights. Yeah? So that's what we're looking at. Now, in our HOPE project, we have 3 working packages. One is rights in the EU, and in the EU, of course, you have directly effective law, and it all works perfectly, doesn't it? Not always, as we know, but in theory, it's as good as national law. Of course, European integration does not end at the borders of the EU, and if the horrible war in Ukraine, which really started in 2014, if we're honest, Oksana, aren't we? So then taught us anything, then it's that. It can't end at the borders of the EU. So the EU has a neighbourhood policy for good reasons, and that started well before Brexit, didn't it? With Brexit, the EU gained a new neighbour in the West, and we experienced that here on the island of Ireland with specific accuracy. And that's why we thought to compare how EU-derived rights, Deidre mentioned the word intergovernmental. These are just international rights, just, I say, a lawyer coming through, not directly enforceable necessarily. However, because they're EU-derived, can they be a little bit better than just international treaties? That's what the work package on the neighbourhood does. And then we have a third work package, EU rights in global dimensions, where we look into human rights in China, what the EU does about it, and how human rights influence trade policy. Now, for this work package, we are very happy to collaborate with the Irish Human Rights and Equality Commission. This is the first of 2 events. The second event in February 2024, long-term planning here, will work on anti-discrimination law and how anti-discrimination law induced by European Union neighbourhood agreements has become a reality in Ukraine and will retain its power in Northern Ireland or not. So, and that's my 3 minutes done, I think, and I really thank the elite who's come to this event. It's always difficult to get people to a July event to come in person. We're really glad that you're here. Thank you for your attention. And before I go to my chair, Oksana, you come up front as well. You've traveled all that way just from Munich today, but still, I think it's the fastest travel.
Thanks very much, Dagmar. My name is Mary C. Murphy, and I'm not a lawyer, I'm a political scientist, and I'm involved with the Jean Monnet Centre in University College Cork. So it's a pleasure to be here today to support this event, particularly given the speakers and the subject matter and the context within which we're having these discussions. This particular seminar series today is focused on citizens' movement in the EU's neighbourhood. And we're effectively looking at 2 key case studies here. One is Northern Ireland, and it seems strange to think of Northern Ireland as being in the EU neighbourhood now, but I guess we need to become accustomed to that. And we're also considering, of course, Ukraine as a pre-accession member of the European Union and a candidate for EU membership. And we're focused on movement rights insofar as they apply to both those case studies. And our speakers today are going to consider and to think about the way in which those rights manifest themselves, to what extent they are operational, how they are viewed within the national judicial setting and beyond, and to compare and contrast the difference between free movement rights as it applies in Northern Ireland and as it applies in Ukraine. So we have a great lineup of speakers for these discussions today, and it's a pleasure to introduce the first of those speakers. And given my own interest in Brexit and in all things Northern Ireland and the EU, Anthony, it's great to have you join us online this afternoon. Thanks for coming in online today. I know you're a busy man, and you've been a busy man for a long time, given the Brexit backdrop. But Anthony is from, Dr. Anthony Soares is the director of the Centre for Cross-Border Studies, and that centre has been doing immensely important work in terms of documenting and tracking the way in which Brexit is impacting on Northern Ireland broadly. But today, Anthony is going to discuss the movement of people on the island of Ireland, and considering whether that is protected or corrupted by the Northern Ireland Protocol and the EU-UK Trade and Cooperation Agreement. So, Anthony, thank you for joining us, and the floor is yours.
Thank you very much, Mary, and thank you also to Dagmar for inviting me. Unfortunately, I'm sorry I couldn't be there physically with you today. But before we actually begin, it is important to let you know where I'm actually coming from. And I don't mean literally, I mean in terms of my approach to the topic. I am, as has been said, the director of the Centre for Cross-Border Studies, which was established in 1999, so shortly after the Good Friday Agreement, to promote and support improved cross-border cooperation, principally on the island of Ireland, but also between the island of Ireland and Great Britain and across Europe. And in terms of that last bit, across Europe, the Centre for Cross-Border Studies is a founding member of the Transfrontier Euro Institute Network, TINE, which brings together a range of organisations and institutions from a number of border regions in the European Union. The Centre also convenes the ad hoc group for North-South and East-West cooperation, working with other organisations on the island of Ireland to ensure the necessary conditions for cross-border cooperation and mobility are maintained in the post-Brexit context. Our flagship project, running since 2003, is Border People. Border People came about as a result of a study of obstacles to cross-border mobility published in 2001 by the North-South Ministerial Council, which contained 50 recommendations, including one recommending the establishment of a one-stop cross-border mobility information website. This is what would become Border People. So the reason I'm telling you all of this is because I'm not necessarily coming at the question of the movement of people on the island of Ireland from an academic perspective, but rather as from someone involved in the practicalities of cross-border cooperation and mobility. And it's important to understand that my focus is on cross-border mobility. So prior to Brexit, there were two central policy pillars that underpinned the work of the Centre for Cross-Border Studies. One was EU cohesion policy, and the other was and is the Good Friday Agreement. These were two pillars of shared frameworks across the island of Ireland. That's no longer the case. Throughout the Brexit negotiations, indeed since 2013, when the UK government began to reconsider its relationship with the European Union, the Centre was very attentive to how Brexit would potentially impact on cross-border cooperation and mobility and on the Good Friday Agreement. We were and we remain particularly concerned regarding the potential for the divergence of rights and what that might mean for social cohesion. What would be the implications for Northern Ireland if those identifying solely as British had a different set of rights than those who identified as Irish? And it's not simply rights to move cross-border, but what citizens can do once they've crossed that border. For those engaged in cross-border mobility, Ireland's and the UK's shared membership of the European Union had offered us the possibility of finding solutions within the common frameworks when citizens encountered obstacles, such as their access to cross-border healthcare, social security benefits, and work-related benefits. Among the EU instruments we relied on were Article 2 of the Treaty of Lisbon, which declared that the European Union, quote, shall offer its citizens an area of freedom, security, and justice without internal frontiers, in which the free movement of persons is ensured. Whilst Article 26 of the Treaty on the Functioning of the European Union defined the internal market as, quote, an area without internal frontiers in which the free movement of goods, persons, services, and capital is ensured. The first paragraph of Article 45 of the same treaty also states that, quote, the freedom of movement for workers shall be secured within the Union, with subsequent paragraphs setting out the abolition of any discrimination based on nationality between workers of the member states as regards employment, remuneration, and other conditions of work and employment, the right to accept offers of employment, to move freely within the territory of member states for this purpose, to stay in a member state for the purpose of employment, and to remain in the territory of a member state after having been employed in that state. As well as establishing free movement of persons as a cornerstone of the internal market, the EU had also moved to establish protections for EU citizens moving between member states for the purposes of employment. Thus, for example, I'm sorry for the kind of references to law, Regulation 883 of 2004 set out rules on the coordination of social security systems between member states in order to, among other things, ensure that movement for the purposes of employment didn't affect the payment of social security due to citizens as they moved between member states. Directive 2004-38, meanwhile, established that the right of free movement of EU citizens, quote, be also granted to their family members irrespective of nationality. Alongside such regulations on free movement, the EU also developed a range of measures to create an environment conducive to citizen mobility. These include the European Health Insurance Card, the directive safeguarding patients' rights in cross-border healthcare, and the recognition of professional qualifications. This regulatory framework, therefore, allowed for the free movement of EU citizens from other member states to the United Kingdom and to both jurisdictions on the island of Ireland. We're in a different place now, but it's important to reflect who we're talking about. According to the 2021 census, 3.5% of the usually resident population in Northern Ireland were originally born in EU member states other than the Republic of Ireland. The 2022 census in Ireland, on the other hand, showed that there were over 267,000 non-Irish EU citizens resident in the jurisdiction. But let's not get this wrong. Pre-Brexit, it wasn't always easy, and we shouldn't forget that many of the complications citizens encounter are due to the way individual member states transpose EU legislation into their domestic laws. Differences in the ways neighbouring member states interpret and legislate for EU directives create cracks through which citizens with cross-border lives can fall. In 2016, within 24 hours of the UK's vote to leave the European Union, Our Border People project began to receive calls from people concerned about their ability to continue to cross the border to work, including from teachers and health workers. It can't be underestimated how much that vote led to anxiety about the future for those living on the island of Ireland. However, now we're faced with a number of moving sets of rights frameworks with implications for the movement of people. We have the Good Friday Agreement, the Common Travel Area, the Withdrawal Agreement and its protocol on Ireland, Northern Ireland, as updated by the Windsor Framework, and the Trade and Cooperation Agreement. It's a confusing an as yet unfinished picture where some of the ability of citizens on the island of Ireland to move across the border to access services in the other jurisdiction now relies on bilateral arrangements between Belfast and Dublin. Whereas pre-Brexit, EU citizens in the two jurisdictions on the island of Ireland, on the island could rely on EU directives to access cross-border healthcare, that is no longer the case. A reciprocal scheme was established to replace the EU frameworks with funding provided by the two health departments in Northern Ireland and the Republic of Ireland. However, the Northern Ireland funding for this scheme ran out in September 2022 when it was closed to new applicants. The Republic of Ireland scheme is still running. I'd now like to show you just 3 examples of how this confusing picture is felt by citizens, how it's made more confusing by government, and how it requires us to ask questions that we didn't have to before. So this is the first slide that I'd like to show, which shows you a question posted on Twitter on Saturday. So the question is from someone, and this is someone resident in Northern Ireland, traveling to France, asking, does anyone know if you need an international driving permit in addition to an NI driving license to rent a car in France? And someone has helpfully answered, I'm just back and used a Northern Ireland driving license. So this is someone from Northern Ireland traveling to the EU, to France, and is asking what do they need. More than 7 years after the UK referendum, and more than 2.5 years after the end of the Brexit transition period, people in Northern Ireland are still unsure as to what they need when they travel to the EU. Whereas before, citizens travelling from Northern Ireland to other parts of the EU did so in the belief that the norms under which they transacted most parts of their lives were common to the rest of the EU and didn't require any additional bureaucratic procedures in order to travel. That rug of certainty has been pulled from under their feet. Now, those from Northern Ireland travelling to the EU are unsure as to whether different member states have different requirements. The EU is no longer automatically perceived as a common space. And of course, many citizens resident in Northern Ireland no longer have the automatic right to live or work in the EU, unless they're looking to do so in the Republic of Ireland, where the common travel area and its associated reciprocal arrangements means they can do so as before. If they wish to do so in another EU member state, then it will depend on whether they hold an EU passport, such as an Irish passport, or if they were resident in another EU member state before the end of the Brexit transition period. But it's important to bear in mind that the right of a Northern Ireland resident with Irish citizenship to work in an EU member state other than Ireland comes with complications. Some of the rights they would have automatically enjoyed as part of an EU member state are now reliant on reciprocal arrangements between the UK and individual EU member states. However, if we focus on the island of Ireland and movement rights under the Common Travel Area, it's important to bear in mind that the CTA was originally designed to facilitate the movement of British and Irish citizens between their respective jurisdictions, with reciprocal agreements to allow them to work and receive certain entitlements and protections in each other's jurisdictions. Although during the time the UK and Ireland were both members of the EU, the operation of the CTA was largely subsumed within the larger EU framework. Following Brexit, the Common Travel Area is again being implemented for the benefit of British and Irish citizens, and not for those other citizens who may reside within the CTA, including on the island of Ireland. The UK's impending introduction of the Electronic Travel Authorisation, which is part of the Nationality and Borders Act 2022, threatened to place a barrier to the movement of non-Irish EU citizens resident in the Republic of Ireland into Northern Ireland. This policy was developed without any sensitivity to life in our border region and would have required those citizens to apply for an electronic travel authorization before entering Northern Ireland. Thankfully, after much lobbying by the Centre for Cross-Border Studies and the Ad Hoc Group for North-South and East-West Cooperation and other organisations, the UK government has committed that it will exempt those non-visa nationals legally resident in the Republic of Ireland from applying for an ETA, not only for travel into Northern Ireland, but also the rest of the common travel area. This is a positive step, but it's not one that will resolve the challenges the ETA system places on all island tourism. What we can begin to see here is how the right to the freedom of movement and associated rights to work is becoming fragmented, depending on residency, nationality, and whether those rights had been enacted before the end of the transition period. This includes those involved in cross-border work on the island of Ireland. Although, again, the Common Travel Area and its associated reciprocal arrangements allows for British and Irish citizens to continue to engage in cross-border work, for other EU citizens living in the Republic of Ireland and working in Northern Ireland, the picture is more complicated. In this case, it depends on whether they were cross-border workers or frontier workers before the end of the transition period, in which case the withdrawal agreement provides for the protection of their rights as they existed before the 1st of January 2021. However, in order to guarantee those rights, a system was put in place by the UK government for these citizens, the Frontier Worker Permit Scheme. The government's guidance on the scheme makes clear that such citizens, quote, must hold a frontier worker permit to enter the UK for work from the 1st of July 2021 onwards, end of quote. Applying for a frontier worker permit is an online process. Now, this is where I want to go to the slide with a frontier worker permit from UK government online scheme. I'd like you just at this moment for you to imagine you were a non-Irish EU citizen living in the Republic of Ireland and working in Northern Ireland before the end of the transition period, and you were applying online for a frontier worker permit. Now, what you have on the screen there is the first question that you were asked. How would you answer that first question? So you're a non-Irish EU citizen living in the Republic of Ireland but working in Northern Ireland. How would you answer that first question? And in order for you to be able to proceed beyond this first question, you have to answer it in English, of course. This process is all in English. And this first question fails to understand the basic concept of what a frontier or cross-border worker is on the island of Ireland. Someone who lives, in this case, lives in the south but works in the north. But that's the first question you have to answer in order to get beyond in the process. In effect, for someone to get beyond this first question, they have to lie and pretend they were looking to live in the UK, not just to work, a cross-border worker. Here we can see that it's not only a case of protecting rights theoretically within the withdrawal agreement or its protocol, but also of how accessing those rights are made to suit the realities on the ground. Our Border People project, in assisting those with cross-border lives, had to begin to ask people questions that were not asked before Brexit. And this is now the next slide. So this is for people wishing to access information, people with cross-border lives, and this is the first question they have to answer. Now, previously, before Brexit, the initial question that the Border People Project asked was just simply on which side of the border was the person living, and not one looking into a person's citizenship or nationality. Driven by the inevitable diversion of rights brought about by Brexit, we now need to ask questions that could be seen as divisive and indicative of a much more fragmented picture in terms of movement rights. But without doing so, we'd be unable to ascertain under which legal framework or frameworks the person was moving across the border and which rights they might have access to. We also need to know this in order to understand what that person is able to do once they move across the border. But I want to finish now by highlighting an important issue. The initial question our Border People Project asks makes it clear that we are focused on British, Irish, and non-Irish EU citizens. We are not including those people who live on the island of Ireland that fall outside these categories. We would strongly hope that in the post-Brexit context, where we can no longer rely on the legal frameworks provided by the EU, that the UK and Irish governments use the common travel area to enable reciprocal arrangements that keep up with developments in the EU. Furthermore, we would hope that both governments recognise the importance of non-EU citizens, including refugees and asylum seekers, living on the island of Ireland, to be able to move freely between the two jurisdictions. I know we can also rely on the great efforts of the Human Rights and Equality Commissions in Northern Ireland and the Republic of Ireland to ensure that we avoid north-south divergence in terms of citizens' rights and equalities, and that the border doesn't become one that operates on the basis of race or ethnicity. Thank you.
Can I speak from here, Anthony, or do I have to get up? So for our next speaker is Oksana Holovka-Havrvsheva, and I wanted to add to the introduction she got already that she is a Jean Monnet professor colleague and also has a Jean Monnet Center of Excellence at her home university. At the moment, like many Ukrainian citizens, she lives between Ukraine, Germany.
There's a lot of Ukrainian citizens who live between countries, Germany, countries and spaces, I would call, because that's not only the country level which matters, but also another dimensions are important. So I chair in Lviv the Jean Monnet Center of Excellence in European Studies, and that's a project we started a couple of years ago, of course, supported by the European Union. And what we tried to do with our project, that is to support our government on the road to the European Union and to do the academic support for governmental initiatives aiming to approach Ukrainian regulatory legislative framework to the European Union standards. I also, for couple of years, I also am the president of the Ukrainian European Studies Association, and that's an organization which actually works in Ukraine and gathers experts in the area in different, as from the disciplinary background in different areas, but who are also personally committed to pursue the European integration agenda for our country, and of course to study, to research, and to promote also the idea of European integration. So my involvement into the European studies in a broader sense are really, I think, since a long time ago. Personally, I'm a lawyer with my background, but I also have the degree in political sciences, and that helps me to look a little bit wider on different dimensions of the discussions we have. The topic I'm going to address today actually is about the EU-Ukraine Association Agreement and whether its provisions are fit and up to date to regulate the movement and the movement rights with respect to Ukraine. Well, and I started to think about that question from different perspectives. First of all, I thought, well, that's a tricky one, because at one hand you can say, well, in fact, the EU-Ukraine Association Agreement is a further step to develop the cooperation in different areas, including also the specific involvement of Ukraine or integration of Ukraine and cooperation on the level of the internal market issues. So this offers the access for Ukraine to the internal market, upon conditions, of course. But nevertheless, this is all the DCFTA is about, how to grant the access, and also the cooperation in the economic matters is really of the utmost importance. And then we have also, and I think, well, from that perspective, yes, that is, if we are comparing the regulations, yes, it is a step ahead, because previously we had the partnership and cooperation agreement. It was a very, very fragmentary understanding what is this cooperation means, and also framework obligations for the parties which led actually to really not to very good practices of its implementation in Ukraine, but nevertheless, lessons learned, we have the association agreement. And then I started to think about the movement rights. And I think when you go through the association agreement and look deeply inside of that, well, you will hardly find exactly the mention on exact rights which are actually guaranteed by that treaty, and vice versa, of course, not only to Ukrainian citizens via crossing the border to the European Union, but vice versa. Migration is a process which takes place in both directions. We are usually talking about the dimension where third countries' nationals or the European citizens of the European neighborhood countries are crossing the EU border and actually moving out for different purposes to the European Union. But this goes the other way around as well. And I think this dimension is also very important for the European Union. And in the case of Ukraine, I will try to just to focus upon some cases where it is important as well. So here I would say, well, when we are talking about those rights, we have to go both sides. It does not work in one way. We need to think about the other countries' legislation and practices. And with regard to that situation, I think, well, and I started to analyze the question from my personal experience, because while traveling to the European Union a lot, you go through all the regimes, how your movement rights are realized. And when you start with the visa application procedures after the collapse of the Soviet Union and all the story, and you go right now almost freely through the border, you might say, well, that's a development, and indeed, but the question is how far the association agreement contributed to that situation so far. Because if you go directly into the association agreement, you will have just maybe two cases where you can relate the movement rights to the whole story. The very first one is from Article 17 till 19 about free movement of workers, because here we stick again to the question of the purpose of travel, which actually determines a lot of issues and has legal consequences for the status of Ukrainians, at least in the European Union. And the next point is, this is, of course, the provisions related to services and the right to establishment, so to the business services, business transactions. This is starting from Article 86, and the regulations here is very, very sophisticated, I would say. So from that two parts, we see here the distinction. In the discussion on the free movement rights from Ukraine, I think then the very third point is also very important, and that's we have a distinct point, the war. Exactly the 21st of February 2022, because migration rights are about ensuring them through the administrations. And you need the cooperation of the bodyguards, migration offices, any other institutions related to the migration sphere in that area. And that is the war which changed the practices. Just to remind you, association agreement signed in 2014, entered provisionally into force, and then in 2017 entered fully into force, contains a number of numerous obligations of Ukraine to deal with. And in the area, in that regard, in the regard to the cooperation of administrative bodies, the issues on cross-border cooperation are important as well, and they are embedded, of course, into the part on the political dialogue. So here we have within the agreement, I think the widespread but fragmentary actually framework for the cooperation in that matters, and it shows I think following as when we are talking about the rights and the free movement rights and the cooperation on the administrative level, we will also have to stick back to the association agreement provisions, but also the provisions of the agreements on readmission and the visa facilitation, because I think these are the agreements which actually contributed tremendously to the realization of the free movement rights, at least of Ukrainian citizens in the European Union, opening the possibilities to travel, to work, and to see, and as I call it, a wider world beyond Ukrainian borders. And here, with that point, I think the cooperation actually goes internal bilateral routes very often, because here the cooperation between the institutions is important, and whereas European Union programs supporting the cross-border cooperation are also here effective. But the point is, what I think the war did, it actually showed to the European Union, and I think to the world, that those administrative provisions regulating migration issues can easily fall down once the political will is here. Because when the war started, you just not imagine how many people traveled across the EU-Ukraine border without having visas, without having valid even Ukrainian documents. That's a part of the migration as well. Because when we are talking about those issues, we are talking about the documents certifying the person and documents certifying the travel purpose and so on, and that's changed. Nowadays, it is slightly coming back, even in Ukraine, because in Ukraine, that was also the situation and the mess up while the war started. And nowadays, even in Ukraine, these documents and documentary support of documents or as a part of migration policies, they are starting to come back. Nowadays, you cannot cross, of course, Ukrainian border anymore without valid Ukrainian travel documents. But only one case it is permitted once you are coming from a direct war zone. That's the point. And I think this is a part which is very important. I think for the European migration policies, it is an example how it can work in the cases of emergencies. It is a time to learn lessons and to see which cooperation modes worked perfectly in terms of border management, cross-border procedures, recognition of documents, evidence actually, for different matters. So this is a part which is linked here very, very heavily, as well as the international part on the consulate cooperation and the protection on this level. This is maybe the very first lesson learned from the situation we have. The very second point is that for Ukrainian migration, we do have a very good question about those provisions which are related to the free movement of workers. And with that perspective, you just can easily say, well, this is not the same level of the free movement rights we can have, which exists in the European Union. This is a separate regulation. In the agreement itself, it is really very fragmentary and says about the reciprocal obligation to provide access to work and for citizens of Ukraine and European Union once the legal grounds are well done. So here, this is like, and that's it. If you go and dig inside and try to discover any other regulations which would focus upon that matters, you will discover a lot of questions. And here, before the war, there were questions of two levels. First of all, at the level of movement of the workers from the European Union to Ukraine. That's a question which I think quite rarely is addressed, because usually people are expecting to come the labor force to the EU, but not people working from the European Union, coming from the European Union to work outside. But I think in legal terms it is the same very, very, very important question, because in case of Ukraine, we do still until today lack actually practices which would ensure this reciprocal protection and ensure equal rights in terms of access, in terms of labor regulation. So that's a huge question. European Union citizens are part of that, so we can, but nevertheless, this is a task Ukraine has to deal with. And in terms of another way around, in terms of Ukrainian migration to the European Union, labor migration to the European Union, well, that was a question and still remains, that was a very important question about the legal status of Ukrainian nationals in the European Union, and that goes within the debate, general debate on the status of the third countries' nationals in the EU, where the EU actually currently has rather also a very specific regulation for certain areas, how to get the access to work and so on, rather than a generalized approach. And here the situation was that, again, the status of the worker were dependent not only upon the European legislation, but also on the national legislation of the countries at hand, and also the national immigration legislation, because it very often goes along the debate of the right to enter the country, to stay in the country, and on the grounds for such kind of behavior, and to reside. And from that perspective, other provisions on services, but also the right to establishment, they are far more complicated and, in my opinion, give more space for that kind of, to say that the European Union, that the association agreement between the European Union and Ukraine contributed to the development of those relations. Because besides the purpose to come to countries for work, you have also to come to country, you can also to come to country on businesses. And prior to the war, actually in certain areas, Ukraine became a place where cross-border movement of business, of services or business was interesting both for Ukrainian ports and for European counterparts. As an example here, I would quote just maybe one. This is the IT sector, which in Ukraine has a very specific and very good regulation, and that was attractive for a lot of European citizens to be registered as a business in Ukraine for that purposes, because that was the domestic legislation which allowed that. So before the war, we had that trend in certain sectors. This association agreement actually coped with other provisions, but also, especially in the provisions of services, was important to boost the economic development in certain branches. Of course, war changes a lot. Now these provisions on businesses are important in terms of for reallocation of businesses, because currently a little bit another way situation turns a little bit around, that Ukrainian companies tend to use the provisions of the association agreements to relocate their businesses from the affected areas, mostly in the neighboring countries, and that's where the association agreement will play also the crucial role, because it foresees the possibilities for establishment and the conduct of certain types of activities. Maybe to sum up, I would say in terms of the association agreement, experiences are rather mixed. What makes them very important, these are the practices which the European Union develops in order to tackle these movement rights issues in the current circumstances. So this is more or less related to the practices which are available now to regulate the migration flows and ensure the status of Ukrainian citizens in the EU. And in that regard, that's well known. We do have the massive influx direction, which grants a temporary status. But again, here the domestic legislation of the countries plays a crucial role to finalize the scope of rights which every person is actually granted. And here, again, the cooperation à la carte, and then like a very, very there is a framework available, but the implementation depends upon the practices beyond that. So far that's my position. And in terms of which changes might be needed for the association agreement, that's an open-end question, I would say, because those changes depend pretty much upon the end of the war, and that's only solely political decision which will play a crucial role in shaping up the future relations between the European Union and Ukraine. And currently what I think is most important to see and to analyze the practices the European states developed to work in the case of migration of Ukrainians caused by the war, because that's a very first example, I would say, where the European Union and the countries actually lowered their migration rules and the domestic legislation with regard of concern to Ukrainian nationals. And then maybe to sum up, to see some consequences and to sum up some of the solutions which will be available upon this, from these practices we already have. Because that's really currently in the unpredictable situation where the war is still ongoing, and actually today in the night we were discussing whether, for example, Zaporizhzhia nuclear plant will be actually exploded today in the night. That there were some discussions internally in Ukraine, and these were pre-warnings of Ukrainian governments to get ready for that. So I think that's rather unpredictable that the association agreement provisions will be changed as according to all the legislative procedures which are needed. But however, once the practices are analyzed and that moment comes just to modify the rules and to prepare better the country for the EU membership, I think that would be certainly necessary and would help very much for the country to become a member of the European Union. So thank you very much.
Thank you very much for this. That was fascinating. You introduce the next one, right?
Thanks very much, Oksana. That was a very sobering presentation, particularly at the end. But certainly I think it speaks to some of the complexity that Anthony was also talking about in relation to Northern Ireland. So we can tease that out more during the questions and answers.
Yes, sure.
That's okay.
And I think it's important to Anthony's situation when we are talking about the Northern Ireland.
Take a microphone because we have people online. He's putting it on. You just need to speak in it.
Okay, you can hear me. I think that's a little bit a reverse situation to Ukraine, because Ukraine is going to become a member of the European Union and needs to get prepared to implement all these provisions. Whereas in the case of Northern Ireland and in the Brexit situation we face, actually another way around, there is the need to regulate the status at hand, and just to be sober and see that these other rights, and they might be actually, the protection level might be actually lowered as such. I think that's basic distinction here, and both ways are really hard to go.
Yeah, exactly. Well, thank you very much for your contribution. We're going to move on to our final speaker this afternoon, who's also joining us remotely from the University of Victoria, and that's Dr. Tatsiana Shaban. You're very welcome, and thank you so much for joining us this afternoon as well. Tatsiana is going to speak about a theme you touched on as well, Oksana, the status of Ukrainian refugees within the European Union. So I give the floor to Tatsiana.
Thank you very much. And thank you very much to Dagmar and to Romain who organized my presentation for today, and to other colleagues who will be listening to my presentation. So just a few words about myself. My own interests lie at the intersection of politics, law, and public administration. And I completed my PhD thesis at the University of Victoria. It was in 2019, and it was about the governance of the European neighborhood, the cross-border cooperation, which analyzed the cross-border cooperation schemes of the European Union with mostly two countries, Ukraine and Belarus. But currently, I'm in Belarus. I'm a non-resident fellow at the Center for Global Studies at the University of Victoria, but I've been in Belarus for nearly 2 years from now. So that's just a few words about myself. And the topic I'm presenting today, it's about Ukrainian refugee and asylum seekers, defining the status of the Ukrainian refugees in the EU neighboring countries. And just to briefly tell you that I was raised in Ukraine, and my first language was Ukrainian. I was raised in the Sumy, Chernihiv region and Poltava region. And then we moved to Belarus. So I want also to acknowledge the contribution of Ales Mikhalevich, who is to this paper, who is was a Belarusian politician, now in exile, and also got a refuge in Czech Republic and became a refugee there. And he also a legal scholar and a lawyer and a member of the European Law Association of Lawyers. So with this paper, in short, we argue that analysis of the fundamental relationship between law and place is very important because it helps us understand the varieties of legal practices, discourses, relations that constitute the asylum system. And we also define specific characteristics of refugee and asylum seekers' status in European countries, Hungary, Poland, and some others. So next. So our main question is with this presentation, I want to answer the question, what is the political and legal response to displacement of refugees from Ukrainian territory? Not just those who are holding documents as being nationals of Ukrainians, but also those who live in the Ukrainian territory. And also one of the most important questions, and how the EU changed asylum for Ukrainians. I think as Oksana already reiterated, that overall it's an EU political response based on solidarity principle rather than the EU dealing with refugee policy per se. So when there is a will, there is a way to do the changes. And this time, the scale of this disaster when Russia invaded Ukraine has changed the calculus in the EU, but for how long we don't know. There are reports of acts of great generosity from ordinary people who literally opened their doors to welcome refugees from Ukraine. And the politics of the EU achieved something that it has rarely achieved before. So solidarity and consensus for an open door policy to refugees, which is really important. So if we go into history, so since 2003, the EU required asylum seekers to apply for protection in the member state they first entered. And this policy is widely known as the Dublin regulations, or the last one, Dublin 3 agreement, or Dublin 3 regulation. But since March 2022, the EU activated the use of a new policy called the Temporary Protection Directive, which provided greater protection for potential asylum seekers and better distributed the responsibility of asylum registrations across the EU. So this directive provided the right to access basic needs. So first, the asylum seekers or refugees, as all Ukrainians are, had the right to go to any European Union country and to access basic needs such as housing, health, work, education, and welfare. So this directive was adopted in early 2000s, but was activated for the first time in March 2022, just a few days after Russia invaded Ukraine. Since then, roughly 8 million people fled from Ukraine to EU member states, while about 5 million benefited from this EU temporary protection scheme. And in its report, for example, the Caritas humanitarian aid organization assessed the situation of those Ukrainian refugees in the first year of protection and detected a quick and prompt response, particularly from countries neighboring Ukraine. Registration of people to access temporary protection was smooth, efficient, fast, despite the large number of arrivals, especially compared to the registration of asylum seekers. However, of course, lots of issues remain, all those administrative, practical obstacles, and of course, forms of discriminations, like discrimination of those stateless people who lived in Ukraine before, such as Roma and others. So, for example, differential treatments of those holding biometric passports versus ordinary internal passports or having no documentation at all, and others. So next. So European initiatives, of course, are not disconnected from global solutions, hence references to global initiatives are necessary. And here there is just a list of relevant international instruments for the refugee protection, which can be activated for Ukrainians. And then next, I wouldn't focus on this much. I will go to the EU initiatives. So I will just talk a bit more about EU temporary protection, like I give a short description, more advanced maybe than in my first slide. So it's the first ever harmonizing measure adopted in the area of asylum law in EU. And temporary protection evolved into primarily an emergency process to manage a mass influx. The point of it to enable immediate protection to refugees and to avoid overwhelming asylum systems through hundreds of thousands, maybe millions of individual applications for protection. And by its very design, it's intended to admit large numbers of refugees. And the politics and perceptions of hosting large numbers of refugees for an indeterminate period is highly problematic in European politics, as we know. And protection of refugees in Europe is associated with long-term permanent obligations to host and integrate people. For this reason, there has been in the past, including very recently, as we know, a strong resistance of all at national and EU levels to any moves of the population. So the Temporary Protection Directive requires the Council to implement a decision to determine a mass influx situation. This has been done by unanimous vote, and the Council implemented decision which did three things: activated the TPD by determining a mass influx situation, specified the groups who are the beneficiaries, designated displaced people, and directed the EU member states and agencies to cooperate and coordinate the management of displaced people with the central role of the Commission. So given the urgency of the situation, as I already mentioned, it came into force right after the invasion on the 4th of March 2022. The same date, the decision was published in the official journal, Article 4. A temporary protection was instituted in all EU member states, with the exception of Denmark, which maintained an opt-out. The decision falls short, however, giving the same protection to everyone fleeing Ukraine, as I already mentioned. And Article 2, in effect, specified 4 groups, some of which may not benefit from temporary protection if they cannot meet the conditions. So member states, of course, implemented some form of registration of those granted temporary protection, but they will not only want to monitor the numbers of people they're protecting, but also required to provide each displaced person a residence permit of some description. Finally, all member states screened those to be granted temporary protection for security purposes, and they are able to exclude particular individuals on those grounds while still respecting the principle of proportionality. So, under the Temporary Protection Directive, there are rights listed, granted under this protection, and they are required to provide the basis in national law for immediate protection for 1 year and then up to 3 years. So member states must provide a right to stay evidenced through a document or something equivalent, and a minimum set of social and welfare rights, the right to work and access for education, to education for minors. And these are also provisions on family reunification, Articles 8 to 16, and the combination of the protection directives and implementing decision should override any faulty national implementation or national measures that provide fewer or lesser protections. However, this is not the case, of course, when you start looking at some case studies. Then next. And before I go to my case studies, or briefly go to my case studies if I have time, I want to emphasize that it's very important to manage the discourse and to manage the discourse of how we talk about different refugee crises, also from a legal perspective, because the respective narratives, discourses either cause or at least accompany different legal responses. Especially the unfolding of the Ukrainian crisis pointed out how strongly the storytelling of the EU leaders and how it differs regarding the different refugees coming to those from, for example, from Syria, Afghanistan, from, for example, Belarusian border during the humanitarian crisis. So being in Belarus, I really want to mention this. This contrast is particularly obvious in view of the recent emergency at the Belarusian border, especially in 2016, 17, 18. In the latter case, the long imagined trend of securitization of asylum issues hand in hand with the fortification of the EU external borders, and it continued. In March 2022, the concerns of many EU member states, particularly those who have been most vocal before about their lack of resources to receive refugees, seem to have vanished in the face of the war in Ukraine, but not in the face of humanitarian crisis on the Belarusian border, for example. When it comes to Ukrainian refugees, which have a preferential treatment and which is understandable and which I fully support, so this constitutes a U-turn in the EU agenda since 2015. It has become clear that the problem lies less in sufficient contingencies for a sudden large-scale influx, but rather a feeling or absence of solidarity before. From a legal perspective, there is no distinction between the responsibility for asylum applicants based on their nationality, and to the contrary, refugee protection builds on the prohibition of discrimination. Hence, it's really important how EU leaders talk their way into applying or not applying EU law and even create EU law. And then next. So when it came to the case studies, it's important how states understand and interpret temporary protection directive. So states are not unified within the European Union in looking at it. Ukrainians can have difficulties, for example, especially at the Hungarian border, like I already mentioned with the Roma population. The legislation leaves a lot of space to maneuver, and however, when the Russian military launched its invasion in Ukraine, as I already said, many countries in Central and Eastern Europe responded immediately by amending their legal framework to provide shelter for Ukrainian refugees. And these countries, especially neighboring nations, not only provided immediate humanitarian help, but also changed the immigration law to allow Ukrainian refugees to work and live in their countries before even waiting for this temporary protection directive being activated. So I wouldn't focus on the case studies. You can read through a bit through my slides. And then next, so we analyzed a few countries so far. It's Czech Republic, Poland, Hungary, Slovakia. For example, in Poland, Polish legislation recognized the legal stay of Ukrainian citizens who fled the war until August 24, 23, 18 months from the breakout of the war, which can be different in other countries. So no extension has yet been announced, or at least I don't know about it. So Ukrainian citizens should file an application at least 2 months prior to the end of their current legal stay. And if a Ukrainian citizen leaves the territory of Poland for more than 30 days, their legal stay is automatically terminated. And of course, there are exceptions for those Ukrainians directed to perform work or services abroad by entities operating in Poland. So next. So the initial reception of Ukrainian refugees in the EU after the Russian invasion was smooth and efficient, is in my conclusion. But there are severe limitations facing the provision of basic services. So many member states faced difficulty in providing access to housing, jobs, healthcare, welfare, and education, despite these services being at the heart of the EU temporary protection benefits. Faced with this discrimination, Ukrainian Roma refugees were going home, being denied humanitarian aid in Hungary, and then next, just a picture of those Roma boarding the train. So it's not the long-term solution with this temporary directive. This will be either the long-term solution can be either the safe return home of those who fled when the war ended, or a commitment to protection under well-established and clear obligations of all European Union states if the situation prolongs, if Russia plays the long game. And if this is the case, EU solidarity and values will most certainly be tested and must endure, of course, if the EU wants to avoid a real migration crisis. However, in a positive note, despite the difficulties of implementing the Council decision and the TPD, at last, the European Union is following its own rules on the governance of mass influx of refugees for the first time since 2001. And it's still too early to predict, as Oksana says, whether the EU will continue to make the use of TPD in the future or discard its plans to retract the directive in the new spec. I think I'll finish here. Thank you.
Thank you very much. I think I get up for my last proposal. Now it's our turn, like Mary's and myself, to provoke you to ask physical questions. I think we also have some justification to do. Why did we put this together? Yeah, I think Oksana had a very good picture in the beginning that we have divergent movements. We have the movement of Northern Ireland out of the EU, slightly withheld by the Northern Irish Protocol, which is still the real framework, modified by the Windsor framework. And as Anthony lined out quite competently, the withdrawal agreement and the Citizens Protection chapter is more relevant in practice than the Northern Ireland Protocol, because it does actually give some rights. So that's the movement away from the EU. And from the Ukraine, we have the movement into the EU, and that's disturbed by the reality of war, where we have, of course, people in need of temporary protection, not only from Ukraine, also from other areas of the world, where we find a disturbing picture of unequal treatment, also practiced by the EU and its member states. So that's what we wanted to bring together in this seminar. And I think we thank you very much for all your contributions, because it came together more nicely than I thought. Yeah, Anthony gave us a impression that, of course, rights are, first of all, only on paper, and they don't always work as well in practice as they should. But if you take the paper away, if you take the rights away, you talked about the rugs drawn from under the feet of the people who were relying on them, then you notice, even if they're implemented unsatisfactorily in most cases, they still do make a difference. And now the people who have been relying on those free movement rights in Northern Ireland in the past have to live in a legal vacuum, which is very cautiously cushioned by some provisions of the withdrawal agreement and the Northern Ireland Protocol. Now, Oksana created a different picture and said, well, this is big hope of the Ukraine joining the EU. How much is that actually reflected in the deep and comprehensive free trade agreement? What a name. Yeah? And you correctly said, well, with free movement of workers, it's not much there. The member states decide how many workers they admit. And then when they admit these workers, they have to ensure that they're treated equally. And that works reciprocally. And does it work in practice? Not always, because the movement rights under services and establishment are much easier to use And if Ukrainians move into the EU under service provision, they have no claim to be treated equally. And they're often treated appallingly. And also, so that's, I dramatized more than you did. So, and now in comes the Russian war, and we get these large numbers of fleeing Ukrainians. And I found it really interesting how you lined out that actually there's still a role for the deep and comprehensive free trade agreement, with companies trying to relocate into the EU and trying to use those elements as well. I wasn't aware of that. We always think of temporary protection, asylum, and how it's working. Tatsiana lined out very nicely how the EU used the temporary protection directive for the first time and how it not always worked smoothly. However, it is the first time it's being used, and what I think all these papers together do, they line out a really difficult framework of contradicting and overlapping legal frames and their use in practice. And we can only leave the seminar with an open question: what can we do to make it work better? Yeah? Immediate membership isn't happening. It's not happening in a war-torn country. Although, let's not forget, there was a war on the island of Ireland when both Great Britain and Ireland joined the EU in 1973. Yeah? So, how can we make this better? How can we do this? So I hope that Mary has more illuminating questions, and I hope you have also questions, provoked perhaps from that discussions. Thank you for your attention.
Thank you, Dagmar. Yeah, there were three fascinating presentations, and I might just comment on Anthony's in particular, given it's within my own area of interest, and also because of, I suppose, the politics in the case of Northern Ireland, which are add another layer of sensitivity and complexity to the situation. It also, I suppose, at the outset, I would say, Anthony's presentation points to, you know, another problematic feature of Brexit for Northern Ireland specifically. Here in Ireland, we tend to focus on Brexit in terms of trade predominantly. That has been the sort of overarching frame within which we've looked at Brexit and its implications for Northern Ireland and for the Ireland of Ireland. And, you know, this really does broaden that analysis in very, very important ways. So the complexity of the situation is troubling, given how complex it is, as set out by Anthony. The lack of clarity for citizens is similarly problematic. It begs questions about how we communicate with citizens, how citizens may become aware of their rights, and how they might come to practice those rights in the real world setting. And then layered over all of that, of course, there's very, very serious identity issues which are brought to the fore in relation to the exercise of these rights, where people are asked potentially very divisive questions. And in a post-conflict society, asking those questions in that way, again, adds to the potential for instability. And I suppose that's something that's troubling as well. But beyond that as well, this is not just about citizens in Northern Ireland, British or Irish, it's also about EU citizens. And I think that's something that's invariably overlooked when we think about Brexit and its implications for Northern Ireland and the protocol and the Windsor framework as well. And also the sectoral impact is very important, particularly, I think you mentioned tourism, Anthony. The sectoral impact for tourism in relation to this complexity and ambiguity around the free movement of EU citizens and non-EU citizens is again another aspect of this discussion. So all I'm doing really is adding to the list of questions as opposed to addressing any of them. But I suppose I might actually start by asking a question of all of you, like, where is the problem here? What is the sticking point, and what is the obstacle to actually addressing and resolving these problems? When I was listening to Anthony, I was wondering, was the bigger problem the British government, or is it the EU regime? or is it the absence of discussion and cooperation between the two? And I suppose similarly that question applies to the Ukrainian case studies as well. What are we trying to overcome here? And what is the obstacle to actually addressing these particular issues? And should I go to Anthony first?
Let's see whether we have questions from the floor.
Do you want? Will we take a bunch of questions together? So, yeah. Okay.
Hi, thank you very much. That was incredibly informative. And like Mary, I have as many questions as rather than answers. I have more questions. As luck would have it, there's an article in Irish Studies in International Affairs by Aoife O'Donoghue and Catherine McNeely from Queen's University Belfast. And their paper looks at mapping the tapestry of human rights, north and south, which speaks to some of what Anthony was speaking about today. And what struck me listening to what you were saying about the border dynamics and then specifically around Ukraine and access routes to places of safety. O'Donoghue and McNeely talk about the manifestation of equivalences and the misunderstanding that we have that we think equivalences are equal when actually legal equivalences are a very different thing. So that speaks to what you were saying about access rights through work visas and or asylum opportunities. So I think my question would be, how can we examine or explore equivalences across the borders between the European Union and neighbouring states, firstly? What do the equivalences look like and how do they manifest in terms of convergence and divergence? So how do those things work would be my first question. And my second question would probably be around looking at what happens, say, for example, in a horrible scenario. If we take Anthony's border, we talk about Derry, Londonderry, and Donegal. So you're crossing the border. If you find yourself to, say, be a Syrian refugee who is relocated to the city of Londonderry, and you want to go and play a sport in Donegal at the weekend, and you find yourself as a Ukrainian person seeking safety, be you refugee with asylum seeker status in Ireland, and under the temporal provision, you find yourself wanting to play a sport in Derry, Londonderry. What are the equivalences in terms of the struggles those people face crossing this border if they have the misfortune to be stopped by either police services on either side of each border? So it's a horrible question, but I suppose it speaks to the differences between Ukrainian refugees versus others who are perceived very differently. The nature of going from an EU state into a non-EU state in terms of Northern Ireland, despite its special status, if you like, and what that tells us about the importance of our perception of equivalences, both legal and perception in terms of how we see them. And it's, for me, it speaks to the significance and importance of Anthony's point around there are rights in theory and there are rights that are chosen to be manifest. In the paper that Aoife and Catherine have written, they talk about Henry VIII powers or discretionary powers for domestic states. And I think that's something that has emerged from the conversation here today, that the notion of discretion of states and what rights they choose to recognize is something that's very interesting in light of what was being said about Hungary and Poland being similar, and then the differences around other states in accessing, Ukrainians accessing that. So and there's an awful lot in that, and I'm sorry, but it's just the threads on it that strike me as something that would help people who have an interest understand how that works. So I have a horrible simulation for you of people trying to cross from Derry to Donegal, and what you think about equivalences in terms of legality, I suppose. Thank you.
Wow.
Thank
I mean, it is very much a Queen's internal discussion. Yeah. Not from you, know what Kathleen and Aoife does, because the whole discussion about the withdrawal agreement, the Northern Ireland Protocol, was faced by this idea of equivalences. And that came from the trade discourse, which dominated it. Nobody thought about persons. And I'm not even sure whether the idea of equivalent regulatory systems, that's a brainchild of the political scientists, which has now seeped over into human rights law in Eva's and Kathleen's article, which I've read. And so can we really usefully apply that idea of equivalent regulatory systems, which we apply to meat stuff and dogs and wheat and Guinness, to people? And I would question that idea of equivalence to be applicable to persons, because persons are not goods. Of course, in the internal market, as Anthony has said, we are all workers and service providers established. We are also goods in a way, but we are different from goods. And that's why I think this equivalent idea, I couldn't get my head around it when I read the article three times, and I thought, well, that is probably why I can't get my head around it, because equivalence applies to goods, applies to quality standards. They shouldn't be applying to people. I think what the article does very usefully is to show how human rights law is limited, because it doesn't apply directly. It can be differentiated. And what I find really interesting with Tatsiana's presentation is how this seeps into refugee law of the European Union, because that is where the member states do not allow the European Union to be properly supranational, because they want to retain their powers. And that's, while you were speaking, I was wondering, would matters be made better if we would have a regulation on temporary protection and the state of refugees, which is unification? This is political dream, yeah? So the member states would never agree to this. But sometimes we need to dream to make things reality. Sorry. So now our speakers had a lot of time to think what they actually say through these horrible questions. Sorry.
Yeah, maybe not an answer to all your questions, but a couple of comments and thoughts together on the topics which are being addressed here too. First of all, a very brief comment to your question. What are we overcoming here? And I think in terms of political, in terms with movement rights and also the policies which have to be developed, I think any rights, they manifest themselves in the context. They are not without the context. And that the context which shapes the execution or the exercise of the rights in any specific situation, any subjective rights. When we are talking about the movement rights or human rights, they are very, very nicely formulated in a lot of international documents. Many countries show respect for them and recognize them, but in fact they are manifested in everyday's life, and how they are protected depends upon the context pretty much. And I think here we have to analyze the context to find the answers to your questions, because migration is a phenomenon which depends upon a lot of issues. And first of all, we are talking about different causes which are beyond the migration, and different legal responses to those situations which arise. In the terms of legal regulation, we have under the international instruments a lot of separate cases, but the human rights law, I think, needs here to be really elaborated further on. The very first part in that discussion here, the refugee status, temporary protection status. I think that's the discussion needs to take place further on, and for further legal distinctions maybe in that regards. But when we are talking about what causes the migration, and merely we have the migration for economic grounds, and then we cover the regulations through the labor-related and employment-related policies and issues. We have the migration which is caused for political grounds. And here we have the Convention on Asylum Seekers and Refugee Status. And that is not certainly what is really hardly to apply the situation of the mass influx, because the Dublin Convention applies in the case when the person leaves the country for political grounds. And here we have the third type of situation, that's a humanitarian crisis, or natural disaster which cause environmental crisis, and we have under contemporary international law cases where we are talking about environmentally displaced persons, like in the case of the Kakhovka Dam, what is the cause here? Whether it's the war or it is the dam explosion, which will cost, of course, it cost internally in Ukraine massive migration again, because you have to relocate people, forcibly to relocate people. That's a lot of issues. But we have that in terms also of international relations as well. And we have the particular situation of wars. I think in terms of international politics and international relations, but also in terms of international law, we rarely think about wars as a separate situation which causes the migration and that kind of mass influx. And I think with that regard to the situation of the war against Ukraine, that's what currently happened. The Temporary Protection Directive shows and addresses the peculiarities of mass influxes caused by wars. The question is whether it will be applicable in to other cases, especially to environmental disasters. That's a very good question. But like in the case of the wars, we have actually to separate two statuses. And if you go through statistics, the statistics which currently actually are available with regard to Ukrainian migration, you will see that mostly Ukrainians apply for the temporary protection status, and they do not seek the asylum. That's a current distinct point. And in the situation in other cases, that these practices were actually hardly applied in other cases to any other situation. And that's where the question of equality arises. Yes, what is here beyond that? And that's also the very good question, because migration, it is not only external influx to the country, but that is also the perception inside the societies. And we do not have to forget about that. Migration is the social phenomenon, it is a cultural phenomenon, and the societies really are very cautious to address those issues. And I think that's the question, and that comes me back, makes the circle complete. Again, the migration is about the context and the societal responses to the challenges which are available. And any solution will be actually only temporary, because you will not find any stable solution for the whole life forever. And I don't think that will be the case. That's in that respect my answer to your question. And that's also the question, and then the issues of equal or unequal responses. This is, again, I think more or less here at the current state, the issue to work on, internally both and externally. But in terms of the statuses, in terms of the refugee status and temporary protection directive, that's a point which has been clearly done. And that I think important. So if comparing both regimes available under the refugee status and temporary protection directive status, we do have differences, and they are huge. And these differences actually mark the behavior and the law applicable to the situation you scheduled, actually, because in the year the legal framework will be different to be applied, and that will mark, I think, the behavior of the migration officer on the borderline. That's as much as to answer to your question. Thank you.
What about our online speakers? Any answers to our questions? I don't know how we get them in the picture.
Maybe I'll again, it's not that I'm dodging the question, but a couple of things. So first of all, absolutely agree. In terms of the whole discussions and the negotiations around Brexit, it was 99.999% on goods, and the people just, the secondary issue, which forgets that goods, the production of goods and movement of goods depends on people, and people have this annoying habit of moving across borders, especially on the island of Ireland. It's a thing that we do. We're annoying creatures, and absolutely agree. Lots of organisations that we work with, including sporting organisations, one of the heart-rending things they have to face is when a sports team of children, a young team is crossing the borders to go and play a match. They can't take some of the team members because they don't have the required immigration status in order to cross the border. People who don't have the right immigration status, who have friends, family living just miles across the border, and they want to meet, and they can't cross. And it's just beyond belief that we on a small island that there isn't the ability to allow for those people to cross the border freely. I think we can get there. There is the will. But I'll come back to an original point. It was mentioned earlier in terms of the Equality and Human Rights Commissions having been before the Oireachtas Committee, and the proposals and recommendations that we're making there in terms of coordination, cooperation between the UK government, the Irish government, and the Northern Ireland Executive and Assembly whenever it is functioning. This goes back. We repeatedly say to governments, and we continue to tell them, that it's about border proofing. It's that thing, people do cross borders. That's what they do. So when a government, whichever one it is, whether it's the Northern Ireland Executive, whether it's the Westminster government, whether it's the Irish government, when they're developing policies, legislation, border proof it. Check what does it mean in terms of people living in your border areas, people crossing the border. Check to see what the implications are. Border proofing to us is a necessary dimension. And there's this thing about the discussion there about equivalence. It's basically, and I refer to it where I was speaking earlier. Even when the UK and the Ireland were both within the EU, didn't mean that everything was rosy in the garden. And it's when citizens, when they're crossing the border, whatever they're doing, whether it's to go and study, whether it's to access healthcare, they hit obstacles. But when we were within the EU, it was difficult, but we managed to find solutions because there was a common framework. Now we don't have that common framework. So now there are pressures on both the Westminster government and, well, the at present absent government in Belfast to come up with to come up with replacement structures to at least try and meet what we had in terms of that common EU framework. But I'm just going to mention very, very briefly, this seems like a really niche subject because it's not about movement. It's actually people not wanting to move. This question about remote working and the move that everybody's made to remote working. And this is a niche subject, but it kind of illustrates something. So there are cross-border workers who want to remote work, i.e. they don't actually want to cross the border. They want to actually stay at home, work for their employer, but do so remotely, as they see many of their colleagues being sent home, being allowed to work from home. But that brings with it tax implications. Because if you stay within your home state, but you're a cross-border worker, then you're liable for double taxation. And there are other social security issues around this and other issues. But just one example. So there's within the European Union, there's the development of a voluntary and opt-in scheme to up the kind of the tax or the amount of hours you're allowed to work within your home state without incurring double taxation. At the moment, it's around 24.9%, but the plan is to increase that to 49.9% of your time could be spent working within your own state, but being employed across the border. Apparently, this scheme is open to neighbouring states, so third countries. The UK does not want to opt in. Ireland hadn't opted in, but I think will be opting in within the next couple of days. They will be opting into the scheme. So here we have a classic example of UK not willing to enter into a scheme. Ireland, as an EU member state, which is going to create divergence, which is going to create obstacles. And we have said this, we have talking to officials, if the common travel area was supposed to be the solution to all our problems, that's what we were being told during the whole Brexit negotiations. We have the common travel area that will solve everything. where we're saying, well, here is a classic example. If the UK doesn't want to opt into this EU scheme because it's an EU scheme, therefore politically it doesn't want to opt into something that's seen as EU, then do it through the common travel area and just say you're doing it through the common travel area. That gets you out of, we're joining an EU scheme. No, you're joining a common travel area scheme. So that's just one example of kind of border proofing, thinking about people and how they do have that annoying habit of crossing borders, and remembering that there are people on this island, on the island of Ireland, and in Great Britain as well, who aren't Irish or British or EU citizens, and that they should be included in that ability to move within the common travel area. Sorry, I'll leave it at that.
Tatsiana, would you have some comments or on questions we asked?
Yeah, I think thank you for a very interesting conversation, and I guess not much to add, but I was thinking when I was listening to answers, I was thinking about regional arrangements, and I think the future can be for these regional arrangements and all the obligations of the states set up in these regional arrangements, and they are in the preamble of the Refugee Convention, and so if you use them and clearly define them, then it can possibly work for the future. Protection or integration or other schemes. That's possibly all I can say.
Now we need to make a decision what we do. Huh? Do we have any more questions from our audience? Did we answer your question properly or engage with it properly? I don't think we answered it. It was too complicated. Our questions were too complicated as well. The whole questions for this event are too complicated to be answered in these 2 hours. And yeah. Because otherwise people online.
Exactly. Well, thank you all, first off. And I'd like to ask, what needs to be done to protect the freedom of movement throughout Europe in the face of the rise of far-right parties who are often anti-immigration?
Technique, can you please repeat the question?
Yes. So what needs to be done to protect the right to free movement in all of Europe in the face of the rise of far-right parties that are often anti-immigration and want to restrict freedom of movement?
Not easy, but it's a really important question to ask, especially considering that we do have elections in the European Parliament next year. And if the predictions for one of the largest member states, which just came out last week, are anything to go by, we're looking at very interesting political conditions. So I think that the answer to that question is both political and perhaps legal. Let's start with the political. The political danger is that we normalize the right-wing discourse, that even people who do migration research from sociological, from economic, and also from legal perspectives start talking about how migration endangers the national welfare state, how the free movement under the condition of equal treatment, which the EU promotes within its borders and partially also beyond with the neighbor agreement, create strains on the welfare state. This is totally wrong. If you do not treat the migrants equally, then you create a strain on the welfare state, because then you create a part of the population who live below the minimum which is defined as a humane existence and who have to gather more scraps to just survive, which drives them into lower paid work, more work, and also activities at the borders of legality. And that then again fuels this anti-immigrant rhetoric, which often comes along with, well, these are all illegals. Yeah? That's first thing. So don't normalize the right-wing discourse. Second, what can the EU do? The EU, by definition, differentiates between their own citizens and other citizens. And it also has allowed, with the emergence of immigration, refugee and migration regulation. At the same time, they have allowed the differentiation within the EU. They have allowed the UK, Denmark and Ireland to opt out of most of the migration discourse. And that needs to stop. So the EU needs, first of all, even if they will continue to differentiate between their own citizens and non-EU citizens, at least what they do with the non-EU citizens, that should be uniform. That would be one legal political demand I would have. And then on the EU also legally should stop demonizing the migrant. I mean, not as long ago, just in the wake of Brexit, the EU has introduced a regulation which allows to pay lower child benefits for children outside the state where the people work. Yeah? I mean, why do we do that? That plays in the face of the right-wing people, and that's those kinds of differentiation, look at them in the small field. I think that's something we can contribute. It's not a full answer, yeah? But it's something, some concrete. Anybody else having more answers on this? Welcome, please.
Maybe I comment on that migration discussions internally in the country. That's, I think, the lesson which country has to go through, everyone, because it is a balance between the economic needs which countries has, but also social perceptions and expectations it has to deal with. And that's really a hard balance to find out, especially if we are talking about the contemporary states and they actually sometimes really struggle to ensure all that provisions which are merely embedded in the constitution, because that's what at the end of the day, legally, when we are talking about that the state activities are aimed to ensure the rights which are embedded at least in the domestic constitutions and according to the rules which are and the principles which are over here. And in terms of from that perspective, I think this is really hard stuff to deal with. And maybe the observation from the political science perspective that in times of turbulences, of course, there is always a strong need to find somebody to blame for. And I think in that regard, if I just would compare maybe my experiences I had to work and to be on the post-Soviet space. That is not only discussion which is internally here for the EU important. That's in any discussion in any country of the world. So this is here nothing new. But once the narratives start to be homophobic, that's a real danger. And I think this is the task which any country has to deal with. That's to draw a clear line where these narratives are not permitted because they are out of the legal obligations and out of any kind, ethical, legal, moral obligations, whatever so far. That's very important maybe to think about as a drawing line on those discussions, because at one hand, once you will not allow people to express their opinions, that's another danger for a democratic process in the state as well.
Can I just comment on that one? I do think that we have to, and when I say we, it's actually, I have to say the media, when politicians are being interviewed and are stating things that are absolutely factually incorrect in terms of the burden that migrants place on social security systems, the benefit systems, or what, they have to be challenged with the facts. It cannot. I think this is contributing to the rise of the far right. It's this ability to just be able to lie shamefacedly, lie on TV, on radio, without being challenged and being faced with the absolute facts. And those facts are actually facts that are kept within the national statistics offices. It's not an article in a journal or whatever, or a newspaper column, or someone say it's actually statistical data kept by the states themselves, which shows how often these lies are being perpetrated. I will never forget one of the back in when I was an academic, I was asked to do a report around the Portuguese migrant workers in the Mid-Ulster area, so rural Mid-Ulster, back in the 2001, I think it was, looking at the arrival of Portuguese migrants. And what I was told time and time and time again is if it hadn't been for migrants arriving in those Mid-Ulster rural towns in the early 2000s, those towns would have died because there was industry there that wasn't able to operate, and it was with the arrival of migration. So to me, that this is me speak as Portuguese, by the way. This is me. To me, when you have migrants arriving, it's a sign of economic success. If you have no migrants arriving in your territory, I would say there's something incredibly wrong, and that you should have a very close look at what's going on within your society, that you don't have that migrant population arriving. But it's also, we have to stop seeing, and I even hate the word migrant, we have to stop seeing people as just producers of economic output. Very often these conversations are about what these people are going to do in terms of production, value. We're so much more than that, and we contribute in so many other ways. It's not just how many chickens' feathers we pull in a meat factory. There's other things that we do when we arrive in another country. But it's going back to this issue. Politicians have to be challenged on air when they are lying about what migrants pressures on social security systems and benefits and what on society. They have to be challenged.
We are now at a time, we have started later, so we should also discuss more, yeah? But we are in principle at the time where people have planned is up here, yeah? And probably most people have plans with their days, and which means we need to wrap it up, yeah? And it's difficult to wrap this discussion up. You want to do some wrapping up as well, Mary, or shall I start and you go on? And okay. So I think we have lined up more questions than answers, and I'm really grateful for the last question, saying, well, we discuss this in a climate where right-wing populism is on the rise, and we will get that rise in the European elections very soon as well. So we need to change the discourse on migration, and we also need to equalize the discourse on free movement and migration, which is so often divided in the EU. Now, looking in the question, what does the EU do, or what can the EU do for movement of people in its neighbourhood, in the neighbourhood which thrives away from the EU, in Northern Ireland and the rest of the UK, and the neighbourhood which thrives into the EU? We have seen that we have the problem of conflicting regimes and conflicting practices, which often even conflict with the legal regimes as well. So, and we have outlined two different ways of solving this. Tatsiana has proposed, let's look to the specific regions and create forms of collaborations specific for regions. And Anthony has said, people have a, obnoxious habit to move across borders. Migration is in the human nature. Oksana said we need to look into the context of rights, how they can be used. And rights, the legal framework is not something which exists in a vacuum. It will always take a different color of people. And I think what we can conclude is one thing, that we need the collaboration of political scientists, sociologists, and lawyers in an interdisciplinary area, which continues to be an interesting way to bring an interesting field to continue to do research in. That's what I take away from today, and I hope that everybody takes away something as well, and thanks everybody. So.
Thanks very much, Dagmar. And I mean, I just echo those thoughts. I think all of the questions were really interesting, but I think that last question is particularly significant because that's the context within which we're addressing and trying to answer these questions. And it's a very challenging context. It goes back to your point, Oksana, about context. And there will be flashpoints ahead, particularly around the European Parliament elections next year. And that's set against the backdrop of the war in Ukraine and what will likely be disinformation campaigns which will be waged around that period, which will be trying to foster division and to further divide people on questions around borders and questions around cross-border movement and questions around migration generally. So there's an onus on all of us to be attentive to that. But there's also an onus on us to really answer these questions in ways which take the sting and the danger out of this broader subject area. So I want to pay tribute to you, Dagmar, for putting these issues on the agenda through the Centre for European Integration in UCC, and for bringing people together in this forum and in this building, actually. I think that's very important to acknowledge as well. So I think on that note, I can probably wrap things up. Yeah, and say thank you to all our contributors, particularly our two contributors who have joined us from another area, from elsewhere, across borders, it has to be said. Thank you for your time. Thanks to our audience members here, those who are here in the room and those who've joined us online. And as Dagmar said, there's more to come, so watch this space. But for now, have a lovely evening. Thank you all.